there and taps his hands and you're just sitting there and he, sits there and rocks back and forth and they show him a bit of another murderer or whatever he is, convicted. Up to this point of a case, not in handcuffs, not in shackles, one or the other, or both, and in orange.
How epic was that? Are you excited? I am. This is my name. Okay. From now on, I just have to write all the Kohberger hearings and all the updates just so I can play that. It makes me so happy. Maybe we'll play it again like halfway through just to like pick the energy back up again. Oh, yay. Da, 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 da. Yeah, it was only like a 1 hour hearing, but it was dramatic. Like I promise, if you haven't watched it, it was dramatic. Everything's dramatic about this. Everything. And look, there's 3 Bryans. 3 times the drama. Hello, everybody. Good to see you. Good to see you. And hello, Murphy Tuffy. Good to see you, Murphy Tuffy. You were early. Gabby. Good to see you. And yeah, Dali did say 1 sec, guys, because we were just like catching up on all the gossipy drama, as we do. CC is here. Hello, CC. Good to see you. The dramatic music. Yes. Ronnie is here. Hi, Ronnie. Snibbles. Good to see you, Snibbles. Snibbles, hello, Snibbles. Becca Lynn. Hello, Becca Lynn. Good to see you, Becca Lynn. And C. Chinny is here. Good to have you back, C. Chinny. Nice to have you back. Alrighty. I'm going to bring in my co-host, like my American accent.
Hey.
Hey. Did you enjoy the opening?
I did.
That's not in a dirty way.
Yes. I enjoyed it very much. It was very well done.
Thank you. Look, it's the music that does it, I gotta say.
Yes.
And I've got to give credit to my dad. He's not feeling too well right now, but he is the inspiration behind all of my musical choices, all the classical musical choices. That's Ride of the Valkyries by Wagner. And it's from a 10 or 12 hour opera, which he used to make me sit and watch the entire thing when I was just a littlie. And I remember that tune very, very well. because that is the tune when all of the fighters used to come in, and they'd all come in. And yeah, I used to not enjoy having to sit and watch 10 hours of opera, but that particular song always comes back to my memory whenever I hear of that. I think it makes me think of my dad. Yes. So, Hella, your opening is very well done. Thank you very much. People love my opening. Very good. Okay, Paige is here. Hey, Paige. All right, so we're going to get into it now. This particular hearing, Miss Ann Taylor, who is just an incredible defense lawyer. Of course, she cops a lot of heat from the guilters out there. I swear to you, if I were ever in Idaho and I was in trouble, I would really love to have this lady defending me.
Yeah.
But she's one of the two, I think, death penalty qualified public defenders. So you'd need to be in a pretty bad way.
Oh yeah.
You'd need to be charged with a pretty nasty offense to have this lovely lady defending you, which I wouldn't wish on anybody. But that said, she is incredible. I love watching her go to work. So we're going to be watching her today. Again, this hearing today, she actually put forth that there be a hearing. She said it would probably only take half an hour. It took about an hour. And as per every hearing in Ladar County for this man, Mr. Bryan Kohberger, it gets pretty intense. So things that are on the table today, and it was the 2nd of May, so it was only a day or so ago. Things that are on the table, obviously discovery issues. So there are tons still of discovery issues. Ms. Ann Taylor, I swear, she has the patience of a saint, but she is losing it because she has asked and asked nicely. She has put in requests. She has filed motions to compel. The state is, in my opinion, they're playing a chess game. They're kind of acting like, oh, did you ask for that? Oh, we're not sure what you meant by that. It's a little bit of playing dumb, but then like, oh, but we gave you that bit. Oh, you meant something else. Oh, sorry. Oh, we're just going to have to look in our files and we'll get back to you. And the discovery deadline is September, I think. September, October. So it's coming up really fast, right? But the problem is that she needs this information in time for her to check that she's actually got all of the discovery, because if it gets past that discovery deadline and she realizes that there's still stuff missing, which let's be real here, there's going to be stuff missing.
Yeah.
And then her expert looks at the information and goes, hang on, wait. It's missing all this crucial data. What's she going to do?
I think she can still request the judge in a motion to turn it over.
Yeah.
But it's shady stuff,
It's very tricky. Yes, Jenny, yes, September. That's right. And Taylor said the state still hasn't given everything she needed from the discovery. This is very bad. I agree. She's a great attorney. Oh, there's so much missing. There is so much missing. In fact, I've got a list. I'll get that out in a minute, but we'll start watching. Hey Benjamin, good to see you. And hey Ghostery. Okay. Now, just before we start, I wanted to just make you guys aware of something that it's just a term, and like I didn't know what it meant. Like the last sort of week or two, it's been thrown around in these hearings, and it's CAST, C-A-S-T. All right. So for those of you who are a bit confused about what this CAST report is that people keep referring to, I thought I might bring up a little bit of research on this and show you guys basically what they keep referring to with this CAST report. Right. So a CAST report comes from the FBI. So it's not directly from the state, it's from the FBI. And a CAST report is, I'll just share this tab and we will we'll have a look. It's not a cut and dry simple thing as per anything that comes from the state or the FBI. So let's have a looky. All right, so I found this thing from 2022, and it's unfortunate because there's not that much detail out there. Hey, it's the FBI, but it tells you what CAST is to start off with. Firstly, CAST is it's actually a special team, right? So let me just have a little look here. So this is someone did a FOIA request revealing how the FBI obtains and analyzes cellular provider data. So just moving on here, an organization that uses the Freedom of Information Act to obtain and publish government records and aid watchdog groups struck proverbial gold when he obtained a training manual published by the FBI's Cellular Analysis Survey Team, CAST. Right, so it's a team. Okay, so it's a group of people employed by the FBI or the FBI agents. So they're a special team, Cellular Analysis Survey Team, CAST. Right. So when the defense asks for a report, it's a report by this team. Okay, so CAST's mission is to support the FBI along with state, local, and tribal investigations through the analysis of cellular call detail records. So that's CDI. And their associated tower information. It accomplishes this mission largely in three ways. One, maintains contact with cellular providers to source accurate information about what data can be obtained from each company. Two, participates in priority investigations and supports prosecutions by providing analysis and expert witnesses. Three, publishes tools and training materials to assist and educate law enforcement officers. Right, so basically this team is set up to support prosecutions and law enforcement. Right, so they're not there to provide information to defendants and help them to exonerate themselves, right? So that's not really it, but they do have access to information, right? So they've got information or they can get information that's on these networks, right? So, and we're not just talking about just pinging towers. There's so much more, right? So when you see that stuff that you see in trials where there's like, the pies, where you can see the cell tower pings, and they're very inaccurate. Like they just show you what tower the phone was pinging from, and it can be a really, really wide area, right? So there's so much more. Oh, hello. Hey, MLS Raid. Kind of because he can't redirect yet. Oh, that's all right. That's so nice, though. And hey, Wendy H.
And everyone, thank you for being here.
Hey, everybody. Okay, so I'm just going to go down a little bit and we'll get to the hearing just in a sec. I wanted to just show you one other important thing here. So what may surprise some people is the list of details that each company can provide. So Google and Facebook will track any conceivable data point on their users and then disclose these to law enforcement with proper authorization. So Apple advertises that user data is stored and encrypted in such a way as to respect user privacy. So it's surprising that its list of programs cited by FBI for which data is available includes Find My iPhone. Hey, that's important. Find My iPhone is really, really, really important because you know how close it gets? It uses the satellite, right? So Find My iPhone can pinpoint down to, I don't know, about a meter, can't it? So the FBI can get that information, like that Find My iPhone information. iTunes gift cards, Apple retail store surveillance videos, iCloud records and files, customer service records, and extracting data from passcode locked iOS devices. I bet if they can get that, they can get a ton more.
Yeah.
So we're talking about satellite information now, right? And it's all up on the cloud. Oh my God, Wendy, you're amazing. Huh.
Thank you so much, Wendy. You are so sweet.
Thank you so much. Hang on, I'll read those out in a second. So yeah, that's all I wanted to share with you guys. That's the kind of information that's available from these cast reports, right? And that is what the defense wants. They're saying that stuff's available. Where is it? Because importantly, as was said by Andrea Burkhart, she brought this up after her analysis of the last hearing and of the alibi response. If Bryan Kohberger, being a criminology student with a degree in cloud-based forensics, knew very, very well that he was somewhere with his phone and potentially somewhere where there was limited cell coverage, if he knew very well he was somewhere with his phone and there's no way of deleting that information up on the cloud, he knows that there is some data somewhere to show that's where he was and that's where his phone was, right? So the FBI has access to that information. Where is it? Cough it up, guys. Cough it up. That's why Ann Taylor is so adamant about getting this cast data.
And
report.
if it would incriminate him, she wouldn't be so adamant.
Yeah. If it would, yeah. If there was anything
yeah.
incriminating in there
The
whatsoever.
prosecution would have it and be raising a stink about it.
Yeah. So what's the deal, guys? Cough it up. So let's start the hearing just with that little bit of information in our minds about why this cast report's so important to the defense. Okay. And
would you like me to read the members?
Yes, let's go. Wendy H, you're a legend. I love you so much, and you're an OG of this channel. You are an OG.
P.
Thank
Lolis Mom. Sissi. Sichini. Julio. 20th Century Fox. McKay 14. Brad. If Josh can't fix it. Mary J. And Valhalla awaits.
Val. Oh my goodness. It's so great. I am so happy to have everybody. And if you are not on our Discord, which you must be because it's so much fun, we have probably weekly big family chats where everybody gets together and everybody has a bit of a say. We have like round table they're not watch parties, they're chill room chats, and they go for hours and everyone just has fun and gets popcorn. But apart from that, we have just chill time, and then we all just talk about trials and whatever's going on in our lives, and we share our puppies and things like that. Everyone, if you're new or if you're not in the Discord, because we have like over 200 members and only about 50 or 60 of you guys are in the Discord, get to the members section, look at perks, and there is a link there. Click your way through. It's really easy to join, guys. It's really easy to join. Become part of the fun. All righty, let's get into it, guys. Thank you, Wendy. I love you. You're amazing. You are amazing. All right, let's get into it. No more further ado.
I have a few things just to sort out today. The first thing I want to talk about is whether or not this hearing should be sealed. What's your position, Ms. Taylor?
Your Honor, this hearing should not be sealed.
Okay. Mr. Thompson? Ms.
Well,
Jennings?
Your Honor, the state's prepared to do its argument today without actually talking about the specific request that we're trying to protect within the discovery request. And so as long as those specifics are not discussed or mentioned, then I think we can go forward with an open hearing today.
Okay. Are you comfortable with that, Ms. Taylor?
Well, what I'm not going to talk about is the content of the court's protected materials that we've asked for a sealed hearing for. What I'm prepared to talk about is why should we seal this particular motion to compel that's set to be heard, and how much else is in the public record, and why there's no compelling reason to seal that, and why that violates Mr. Kohberger's constitutional rights. So if I talk about things that are in the affidavit, and if I talk about things that we're seeking that the state wants to hide, I think that's fair game for the public to hear.
It's the challenge here is that both sides have agreed to seal all the discovery. There's a lot of stuff out there, and so I hope that you can both honor that at this point, because down the line, maybe some things do have to discuss. We need to discuss very specifically that maybe both sides don't want that out in the public, because it is a fair trial goal here. And if we start arguing about the case itself, the trial, and the evidence that you're gonna present, both sides, gets more complicated and may be prejudicial to one or the other. So I guess at this point we'll keep this open, but be careful. I mean, I've read everything, so I know what's sort of out there and what you're concerned about. And some of those materials or potential evidence could be prejudicial to the state, or it could be prejudicial to Mr. Kohberger. So my job is to try to keep on a balance here, a neutral balance, where when we get to the trial, if we ever get there, that it'll be fair and we'll have been determined in advance. Okay, so keep it open today. If something comes up and we need to close it down for a period of time to discuss a particular situation, then we can do that. Okay, so it really, I think at this point, it's the state's motion to close the hearing completely on May 14th. I believe, I'm not incorrect, that you both have stipulated to closing May 16th, which is related to the IGG.
Your Honor, our position is that's the only part that should be closed, and that's because we want to talk about the content of the materials protected by the court's order, and so that one's appropriate to close.
Okay. Okay, I think I'm on the same page. But great. Okay, Ms. Jennings.
Thank you, Judge. So, Judge, the applicable authority today in determining whether or not we should close the May 14th hearing is Idaho Administrative Court Rule 32 and Idaho Code 74-124. Both contemplate balancing this public right to an open hearing versus the interests such as privacy, safety, and the right to a public trial or to a fair trial. In deciding whether or not to file the motion to close the hearing, the state weighed those interests and ultimately came down that the need to protect the privacy and the sensitive information and ultimately protect the state and defendant's right to a fair trial outweighs the right to an open hearing.
The state's right to a fair
Feel
trial.
confident that when the court does
Talking
the
about?
balancing test, it'll come to the same conclusion.
Just imagine Sean in here.
The beginning of this case, attachments detailing the specific discovery request have been filed under seal. In line with this, on April 4th of 2024, just about a month ago, the state and defense filed a stipulated motion to file all future attachments under seal. Today, we're specifically discussing the defendant's fourth and fifth motion to compel discovery. Concurrent with the defendant's fourth motion to compel discovery, the defendant motioned the court that the details be filed under seal.
Lady, you're talking about discovery. You don't. This is about hearings. I don't know why you're conflating the two. There's discovery and then there's hearings. We're talking about whether or not to close hearings, not whether or not to seal discovery. Do you think the judge is stupid?
Citing Rule 32. Concurrent with the fifth motion to compel discovery, both parties stipulated to file citing Rule 32 as well as Idaho Code 74-124. So the state followed course. We have filed all of our responses under seal and then filed this motion to close the hearing to discuss those previously sealed details. Now the defense is taking a contradictory position and asking the court to ignore all the previous filings. And this is just entirely inconsistent. To be clear, the state has nothing to hide.
Oh.
However, it's crucial to protect, as we have been trying, the integrity of this case, and that we protect, ultimately, the right to a fair trial. So let's look at the factors. Balancing a public's right to an open hearing and the party's right to a fair trial. Let's go to the factors laid out by Rule 32 and Idaho Code 74-124. And when we do that, for defense's fourth motion to compel, Item 1, Subpart A, discusses federal grand jury materials. Those are exempt from disclosure by federal law, as well as Idaho Code 74-104, subsection 2. What they specify as subparts B through N, all of those items discuss evidence related to this investigation, of which disclosure would, 1, interfere with enforcement proceedings pursuant to 74-124, subsection A, deprive the defendant a right to a fair trial and the state, subject to 74-124, subsection B, and Rule 32, subsection E. And it would disclose investigative techniques or procedures which are exempt, pursuant to 74-124, subsection E. For defense's fifth motion to compel, Item 1, subparts A through J, all deal with the investigation. All would be exempt pursuant to the same authority just cited. Subparts K through M deal with the names of private citizens who were interviewed, and disclosure would constitute an unwarranted invasion of personal privacy, subject to 74-104, subsection C. It could contain intimate facts or statements of which would be highly objectionable to a reasonable person, exempt under Rule 32 I to A, or invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy, under Rule 32, subsection 3. Subpart N through O is exempt under interfering with enforcement proceeding, depriving the defendant to a fair trial, as well as disclosing investigative techniques or procedures. Item 2, subpart A, names a private business and is exempt under the previously cited authority. Item 2, subpart B through L, deals with the investigation again exempt under 74-124A, subsection B and E, as well as Rule 32, subsection E. Item 3 names multiple private businesses. It's also exempt under the same subsection, 74-124A, B, E, C, as well as Rule 32-12A and 3. Subpart I deals with the investigation, exempt under those same authorities. Subpart J involves a private citizen, exempt under those same authorities. Subpart K through B deals with the investigation and is exempt under those same authorities. Item 4 deals with IGG information, which has been sealed and is under a protective order from the court protecting its disclosure. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in media.
Oh,
The defendant will get his
Oh
day,
yeah, no, never.
and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules
right,
of
Ariel.
Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's 4th and 5th motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings. Prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Okay, thank you. May 3rd might be a little quick.
Well, Your Honor,
Tomorrow,
right, but our motion was filed over a week ago.
right.
So everyone's been on notice of what the state was asking for.
God.
Thank you. Thank you, Ms. Daniel. Ms. Taylor?
Yeah, that's
Thank
good
you, Judge.
day.
Our discovery requests have been filed for months and they've gone unanswered
Let's
too.
go.
So if we want to talk about being on notice for something, we can talk about that.
Can I just add, because I've read through all of the 14th bits. and
Shade.
it's- I mean, some of the information, it seems anyway, I mean, I'm not, it's hard to know, okay? But it seems like the state has provided and has responded to some of those requests, and some they're still waiting to get that information. So that's the impression I had. I don't know if you disagree with that or not.
I would say the court is maybe in part right, but there's a lot of other parts to those 4th and 5th, and the court's referring to our motions to compel, not discovery requests themselves, but they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
And which is fine. I'm prepared to talk about why this needs to not be a closed proceeding today. But I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things, and we'll talk in depth on the 14th about what they mean and some of the ins and outs that go into play with those. But there's a lot more than just meets the eye. With regard to the hearing on the 14th, the state directs the court to look at Idaho Court Administrative Rule 32 and Idaho Code Title 74. And those really talk about documents that the court can seal. And both really are in, if you look at them, they are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, it's been brought up that we've filed a lot of documents under seal. We have. Yep. Those are documents that end up in the public record that thousands of people can read. And we filed those under seal for expediency in saying this is exactly what we want from discovery. If the court looks at the documents, and the court can and probably has through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so for expediency, we filed those under seal and for the reasons outlined in Idaho Court Administrative Rule 32. But what we're talking about now is a public hearing when the state has decided to not give us information or to drag their feet on giving us information. We're talking about a public hearing where we have a right to be in the public eye, a public hearing. Bryan's the one with the right. It's his Sixth Amendment right to have a public hearing. When the state wants to close a hearing, or any party, and the other party objects, which we do, the court is guided by case law in the state of Idaho and the backdrop of his Sixth Amendment right to a public trial in the United States Constitution and Article 1, Section 13 in the Idaho Constitution. So in the backdrop of that, the court is guided by case law. And the specific case, there's a couple of Idaho cases, State versus Kimbley and State versus...
I'll just stop for a second. And people listen, I'd like to just answer you for a second. So what are all the hearings for? Defense asked to schedule dates, a few a month for hearings. Curious as to what has to get done. Thank you. Okay, so there shouldn't be all these hearings. The problem is that every couple of days, every 10 or so days, what's happening is there's problems with the discovery. So Ann Taylor asked for this one. Not only problems with the discovery, problems with miscommunication between the two parties, also about things like what is going to be sealed, what is going to be closed. There's all of these issues between the defense and the state. It's like a chess game. It's really problematic and it's causing everything to be delayed. And what's happening is people in the public are looking at it and going, oh, the defense is just causing all these problems and trying to make it drag out. No, I can guarantee that's not what's happening. For example, this whole situation with the alibi, there was a deadline for the defense to come forth with the information regarding the alibi, and they did. But there was also very strong wording at the end of that alibi statement saying that the defense, the state needs to come forth with further discovery for their expert. And then there was the state coming forth and saying, well, what do you need? We've given you everything. And then the defense is like, well, no, you haven't. There's more. We need the FBI cast report. And that was what I was talking about earlier in the stream. And now there's this issue about whether the hearings are to be closed off so that the public can't hear them. And now the state is saying, whoa, that's a turnaround because you wanted the documents to be sealed. Well, that's documents, not hearings. So here there's all of this argument back and forth about these issues that unfortunately they're not going to be solved at the intervals that were planned. Because if we wait till the intervals that were planned, then that just holds things up further. So it's going to, what's happening for expediency is that there are these shorter hearings, like these half-hour to 1 hour hearings every now and again to try and solve these roadblocks. So I think it's quite good that the judge is allowing them to come in every now and again and try and solve these issues that are coming up. He's kind of like the dad. He's like, come on, guys, what's the problem? What's holding you all up? Can we try and fix it? And you can see he's just like, please, I like fighting children. But yeah, that's the way I see it. Does that answer your question, Pilola's mum? Why are all of these hearings? Because it does seem like an inordinate amount of hearings, but I think it's because of this sort of chess game that's going on, this strategy.
Yeah.
Hey, Bob, how's it going? I think a lot of the bottleneck is getting info from the federal government. Idaho relied heavily on the FBI to try and solve the most. Yeah, and nothing's coming forth from them. And I don't know whether or not the state's really trying to get them to help, because the thing about it is, like, why would they want to get information from the FBI?
Yeah.
What good's it going to do them?
Yeah.
I like the judge. He wants to move on. I feel like the judge is behaving a little bit like Homer Simpson. Like, he's kind of like, duh. I don't know. I'm not loving the judge. I think, like, he wants to move forward. He wants to get it done. He wants to get it off his docket, you know.
Yeah.
He's also acting a little bit like, not my problem, you guys sort it out. And he's, every now and again, he's like, oh, what's the cast report? Like, come on, man. You know what they're talking about. He acts dumb a little. The state's reason for closing the hearing, like, we are talking about private businesses and private parties. What the fuck? Why not close the whole trial since you're going to be talking about something? Yeah. Okay. Look, no, this trial is going to be open, and you might as well keep the hearings open. And yeah, there's only one man who has a right to a fair trial, and it is that man right there who is facing a death penalty. The dad needs to stop it for real. Like, yeah, I'm empathetic because he lost his daughter, but, like, it's not the defense's fault. Yeah. Unfortunately, the Goncalves family have absolutely decided that this is the guilty party, that Bryan Kohberger did it. They're not willing to hear any argument whatsoever. And unfortunately, they may be wrong. They may be wrong. And there could be another killer on the loose, and they're just not willing to hear it. Yes, thank you very much. Cool. All right, let's keep going. Let's keep going.
Olivine, and they refer the court to Waller versus Georgia, and that is at 467 U.S. 39. And that puts forth the test that the court should look at when determining whether to close a hearing or leave it open and let it be a public hearing. And that the court has to find that there's an overriding interest that the hearing should be closed. In this case, in this hearing, that's not what's happening. The court would look at Bryan's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider that this isn't the state trying to protect Bryan's interests at all. He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court should look back through the history of this case. This is our fourth and fifth motion to compel. Motions to compel 1, 2, and 3 were public. They were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context. That's what they're doing when they want us to do this in private and not let the state know about the full scope of the videos that are out there that they haven't given us. That is the state keeping things in a vacuum to control the public narrative. And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IgG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Kohberger in it. So that's out there in the public. But that order was to protect information, the IgG information, that they say details how the state got to Bryan in the first place. That's been sealed. That's fine. We respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Bryan have to have his case when he's asking for this information be done in a little vacuum where the state says what the public can hear and what the public can't hear? Another example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Bryan's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that and that it starts a long time before the little clip that we've received. To do this in a vacuum, Judge,
Curious.
when documents are filed.
Okay, so that's interesting. So there is some CCTV footage of the supposed perpetrator's car, the white Elantra, getting about, that has been edited. Does this ring a bell? Anybody? Has anyone heard of some footage of some defendant that has ended up in discovery that's been edited? That's happened before, hasn't it?
Yeah.
So, yeah, apparently the audio has been taken away and it's not been provided in full. Yeah, Rittenhouse, Bob Masabo. Yeah. I was thinking about Ty, actually. But yeah, sure. Dali's like going back through his Rittenhouse brain.
Yeah, no, that happened in Rittenhouse.
Yeah, maybe their motion activated camera is slow. Oh yeah, Karen Reed, sure.
Yeah.
So this is a problem, isn't it? This is a problem. So is
Well, yeah, in Rittenhouse they compressed the video, and when they gave it to the defense, they used Handbrake, a video editing software, to compress it, and then blamed, and then emailed it and blamed the email compressing the file. Except during closing, there was a screenshot of the prosecutor's computer, and he made this whole blustery deal. I don't know this technological wizardry about editing videos, and I don't know how to do all that. On his computer is a tool, an icon for Handbrake, which is a video conversion program.
They blame the attachment feature.
Yeah.
Right.
And it shrunk the file by 75%.
Oops.
Yeah.
Oops. Yeah, how convenient. I I don't think for a second these people are dumb. I think they know exactly where the footage went, and I think they know, where the original is. So, yeah, I think all of this stuff is on purpose, all of it. Is Dave here? What do lawyers do before all this internet camera things? What do lawyers do before all this internet camera things? I don't know. Maybe they just don't include stuff. Yeah. Or this is the thing. What are gonna do in the age of deep faking AI? Oh, look. That's really taking it a whole nother level. Like, if the state would go to the level of actually like using AI to fake someone doing something, that's really pushing it. I don't know whether or not we're going to ever see that. That would.
Oh, I'm sure we will at some point.
Oh, maybe we will. Hey, bye, Franz. How's it going? How did they solve crimes before?
I don't know.
Okay, I know why. I know how. They would use actual direct testimony and like fingerprints and things like that. I've watched a lot of trials from like back in the day, and like documentaries on old cases and things. They'd used like good old police work with testimony from witnesses and indents in the sand and stuff like that. And it would be a lot more circumstantial evidence, compounded circumstantial evidence, than video footage and stuff like that. So, and juries would weigh the evidence based on that. And maybe there was less state intervention. Like, maybe it would be a lot more about catching the real killer. Maybe. Yeah, forensic evidence based on old-fashioned forensic evidence.
Or like blood type and stuff like that.
Yeah, things like that. I'm sure there was still a lot of people wrongly convicted.
And a lot
if the glove didn't fit, you must have quit. Yeah. Oh, my God, for real, it could happen in the future. Yeah. We installed a tiny Google camera into your eyeball when you're born.
Yeah.
Oh God, I don't even want to think about that. All right, let's keep going.
Under seal, that's fine. Those are documents, but this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Bryan has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that people can see it's not this neat little package. So people can start to wonder if Bryan's innocent. Your Honor, Bryan is innocent. And he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
God bless the USA.
You know, I don't know where they stop though. I mean, if we start pulling out all the potential evidence for the trial, before the trial, then does the state get to respond to that? And that's where does it start? I mean, or stop? It just is a roll of that. And so either side, okay,
right?
That it sends to the public that it is not. You don't get the context. They don't have the context. The public. You have the context. You want more context. I get that. But
okay, dude, it's too late. Right? You can't go back now. There's too much stuff out there to say that you you can like start closing hearings now, because you can't just put stuff out there because people don't have context. It's too late.
Yeah.
You can't just shut things off now. Right? So I get it. People don't have context. They already don't have context. They already have been encouraged to share around this PCA right from the beginning, which is full of untruths. And the state has already admitted that it's full of garbage, right? So they've admitted that there's a bunch of stuff in there that's not true. So too late now. So what are you going to do? So you're going to close it off now? Are you going to stop the hearings being public now and wait till trial, and everyone just is happy to be convinced that he's guilty, when there is supposed to be a presumption of innocence? No, that's not right. That's not right.
Yeah.
It's really difficult to just open that up and talk about particular issues in the case without talking about the entirety of the case. And that's what trials are for. I mean, I totally understand that Mr. Kohberger has a constitutional right to a public trial, but having a hearing is not a trial. That's something different. And so that's why, that's where the balancing comes to, if you want to answer that.
I do, Judge. The Waller versus Georgia case is in the context of a motion to suppress. If the court starts closing hearings now, when the court hasn't closed the other motions to compel, what's the court going to do when it comes time for a motion to suppress? Those are coming. Many of them are coming. We want the hearings in public. The state has dropped bits of information with different filings they've made all throughout the way. This can't be done in private. It just can't.
I would say both sides have said in their motions or in their briefs that they've disclosed, certain things, and it's a change. See that because both sides have agreed to seal a lot of these issues of evidence in the discovery. And so all of a sudden it just does feel like it's moving in a different direction. But I understand what you said. It's like, this isn't about the discovery, this is about the hearing.
Your Honor, those are discovery documents, and there are things in there that the state's chosen to respond to. The state selected which things that we have to have a hearing about. And these are about things that are in the state's possession or control that we want them to give us, and we're asking you to order them to give us these items so that we can do our work, so we can complete our investigation. It's not any different at all. Sealing the documents, I think that needs to continue to happen. That there are a lot of names in those documents and requests for follow-up. We don't have to do that. I do think those are fine, and I think they're different because they're documents that are going to sit in the public record they're different than having a hearing of things that the parties haven't been able to resolve on their own that the court needs to resolve. Public has a right to see how its business is carried out. My interest is Bryan's right. But I would ask the court to remember the history. We've had motions to compel 1, 2, and 3 in the public eye. All of a sudden we get to 4 and 5, and we understand the subpart of 5 that has to be in a sealed proceeding. That is going to directly deal with documents the court has ordered be protected. That's completely different than when the state won't give us bits of information that's within their possession and control that we need to prepare our case. Your Honor, I would ask the court to consider too how much pressure there is to get to trial. We've heard the state say they'd be ready by this summer. We've heard the state say they're going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. They're just not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure of let's get to trial, I think the public has a right to see, and Bryan has a right for the public to see that we're trying the best that we can. The court offered to do what it could to speed this up. Having hearings about things that shouldn't be closed, that we object to being closed, takes time. There is no change in our habit or our practice filing documents under seal for things that meet Idaho Court Administrative Rule 32 subsection I, and us asking for a public hearing. There's nothing inconsistent about that, and that's the way we've carried out the case.
Thank you, Ms. Taylor. Response, Ms. Jennings?
Yes, Your Honor. Ms. Taylor's argued, and multiple completely false narratives are the exact reason why this hearing should be closed. Yes, defense has a right to a public trial, but that is not the right to having all hearings open to the public. The court's right. There will be a day for this, and that is the trial. But we shouldn't be
Okay, Pila's mum. So she, Ann Taylor, is one of the, I think it's 2 death penalty qualified public defenders in Idaho. So yeah, she'd probably know Bill Thompson, and so I can't remember the other prosecutor. So yeah, they probably know one another. They're colleagues. I don't know how well they'd like one another, but they're professional acquaintances, I suppose. Ann Taylor is extremely well respected in law circles. I can't remember what the other death penalty qualified defender is, public defender is in Idaho, but obviously that's a very high rank to attain. So death penalty qualification is it's a very specialized area. So yeah, you're literally giving someone's life to defend. So yeah, and you can tell she knows her stuff. She's a very, very, very good lawyer. I don't know whether she's also in private practice as well. Often they are, but yeah. No, you're absolutely right, Pila's mum. That's why you watch live streams. And I only know this stuff because I've been hanging out with lawyers and watching these things myself with people more learned than myself. More learned than myself. We love it. You ask great questions. You get great info in return. Conflict of interest and attorney Ann Taylor because she represented a family member of deceased victim. I remember that. But this stuff all needs to be disclosed to the court, and the court needs to make decisions. So there's nothing being hidden here, Ghost Tree. Nothing being hidden. So Ann Taylor is accepted as part of this case. It's all been disclosed. There is nothing being hidden. It's all above board. So no, there's no conflict of interest. It's been all put out there. And it has to happen. You can't go ahead with a case like this with a potential conflict of interest. But thanks for bringing it up. Cool. All right.
discussing all the evidence that we're going to hear at trial prior to that. There's no right to try this case in the media. The case law that the defense relies upon has not extended this balancing test to these types of hearings. The hearings are about, or the cases are about trial. And yes, they extended it to a suppression hearing, which was so interrelated to the trial. Waller v. Georgia primarily stands for the proposition that any closure, it gives you this balancing test. We just went through the balancing test and the state gave you the reasons for why this meets the test for closing the hearing. As far as being inconsistent, I would just note for the record, we have had one hearing regarding motions to compel. However, at that hearing, this is your order. At the outset of the hearing, the parties informed the court they had reached agreements on all issues except request 160. We discussed one request and it had to do with training records. That is not what we're contemplating discussing at this hearing on the 14th. I've gone through the multiple issues and subparts, as well as the reasons why we cannot have this discussion in an open forum.
Thank you. Want to respond to any on that, Ms. Taylor?
Well, Your Honor, we had the entire IGG state's motion for protective order and our objection to that in a public forum as well. That ends up resulting in us receiving documents that the court had a protective order on, and we can't even share with our investigators that come to court with us. And we've abided by that, and we understand that. But the entire hearing leading up to that was done in the public eye. In that particular hearing, they talked a lot about DNA results on a knife sheet. That I'm sure benefited the state to have that in the public eye.
Yeah.
What we're going to talk about on the
Huge.
14th, Judge, I don't have to name any private citizen names. I can talk about records that exist and why we should have them without naming private citizen names. I can talk about the videos that they've not given us. They're not about the business. They're about videos that were collected by the police. I can talk about those in the context of the police reports. And by the way, those are all things that are talked about in the probable cause affidavit. And I can talk a ton about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of
That's the thing. I don't want to talk about those particularly. And I guess I'm reminded, okay, in your comment about the IDG, because once again, I'm in this position where I have to make decisions blindly to some degree, and that's what the case with the IDG. I mean, I had to go through all of that information, and then I provided most of the information to you. Okay, to the defense, so that you could evaluate that. I feel that the same way about there's a lot of stuff, okay, that you're arguing about, and the state is arguing about, and I think it's complicated to just open that up. I think that maybe we could go through a closed hearing and then open up what you feel needs to be opened up. But I can't make that decision in the abstract. So that's my worry, because I went through all this last night again, and I thought, how do we really fairly deal with each one of those issues? There are a lot of issues.
I agree with you. There are a lot of issues, Your Honor.
Oh, yeah.
I would ask you to look at the probable cause affidavit and read the parts where they talk about relying on FBI agents and the cast report and different cell tower data. Your Honor, that stuff's in the public eye. Why can't I talk about what they refuse to give me in the public eye?
Well, one of the things that we want to talk about today is I just got motions for subpoenas, duces take them to the FBI. I mean, it's really difficult to get information from the FBI.
Say that again.
They know that. I know that. We have we have to jump through a bunch of hoops to get particular information from the FBI. That is not the state's issue, although maybe it should have happened 6 months ago.
That's the state's.
I understand that,
Yes.
but
Thanks, Judge.
that is one of the things that, I mean, we can maybe address that today too. I don't think, thinking that you don't have an objection for me to sign the subpoenas.
No, Your Honor, I don't have an objection for the court to sign the subpoenas to try to get the information.
So I
That
can
doesn't-
sign that, I can sign that.
Sign.
You can sign that.
Now.
You can sign that. Anything you need to sign to get us the things we want, please sign.
I'm with you. I'm
That-
trying to do that, and you know,
But-
from what I've seen, I mean, I think the state is trying to do that. I know that it's not satisfactory from your position, but
And
there's
those-
a lot of issues in this case.
And Your Honor, that's really a lot of what we're going to talk about on the 14th is the timing of these things,
Right.
not the full content of what we think these things might show. We don't know. We don't have them. They know.
Likewise.
So I think the timing is important. Your Honor knows how much pressure there is to get this case to trial, and Your Honor also is aware of all the things that we have to do. And when we make a request and months later, you're asked to sign the order so that maybe we can finally get that information, that timing part is important for the public to know. That's not the content. I'm not going to talk about the content of that subpoena you just brought up. I don't need to talk about that at all. But I can talk about the delay in this and why there's a delay in us being ready for trial. That is fair game for the public, and that is something Bryan has an interest in having public. So I don't have to talk about that content. That's not the issue at all. But the things that are laid out in the probable cause affidavit that has been on the court's public website for a year and a half now, it makes no sense that I can't ask for those things in the public when they're things that the state said they relied on. That just makes no sense. I have one more ask when we're done with this issue.
Okay. Thank you.
Hang on. I just want to make a comment very quickly. David Bird. It does beg the question why he's still in custody, but come on now. In some fantasy world, he would be released.
Yeah.
Yep. And welcome to chat. Nice to see you. Great question, C. Chinny. Why is the judge asking what he can sign, or shall he sign it? Do you want me to sign it? Shall I sign it? Do you want me to sign the subpoena? Dude.
Yeah.
Hello. Why is it not?
It's in front of you.
Why is there a subpoena not already signed like months ago? Hello.
It's absurd.
And you just said yourself that it's very difficult to get things out of the FBI. Well, you're a judge. You
Yeah.
can help. Hello. Here's the paper. Please sign it. Do we need a carrier pigeon to like take it over there?
Yeah.
Goodness me. This is ridiculous. Please. Yeah, you're right. He's probably safer in custody. There are people who want to boom boom him, apparently. It's like he doesn't know how to judge. Yeah, well, courts move very slowly, and we understand that. We're aware of that. However, for the judge to just simply sit there and admit that it takes a lot to get things out of the FBI, and then just be like, oh, do you want me to sign a subpoena? Come on now, please. Okay, let's go.
I mean, are you expecting to make the decision right now? Maybe not.
Well, Judge, you should just make the decision to have the hearing open. And if I start to talk about content, then maybe you can talk about it then. I don't agree any part of it should be closed. I don't agree any part of the hearing should be closed. And I think you should make the decision now. We're 2 weeks away from this hearing.
That's true.
2 weeks.
Judge Boyd would just be like,
Is that right? Or
do it.
We're less than 2 weeks. We're 12 days.
All right. Well, I kind of mentioned this a moment ago. I just feel like we need to get into the details, okay, of all these issues before I open it up. So I'm going to close that hearing. Now, that doesn't mean that after we sort out all of those issues and I have more understanding of why you aren't getting what you want or what you asked for, or whether or not there is something that you've asked for that doesn't exist, or that some of the materials are holding with the FBI, and that we need to get that. I mean, those are all really complicated processes. And I would feel much more comfortable when, again, I'm trying to protect a fair public trial and not have a maybe not intentional unfair hearing, okay, that goes out to the public. I think that's the balance for me. That I want to see what all the issues are, the arguments from both sides, so that I can make a more informed decision. So I'm going to close the hearing. At some point in that hearing, maybe we can open up part of it. But I need to dig in, and you all need to dig into exactly what is the problem with each one of these issues. All right, so let's talk about the schedule. Okay, the state asked for this, some disclosures of witnesses, expert witnesses, exhibits by May 3rd. I don't think that's particularly practical at this moment. I know that you had, and I'm not looking at it right now, you've had another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. That seems more practical. Okay, so I will put an order out, schedule order for providing. I don't know if the state really knows what you do until you see what they have. And you're shaking your head, yes.
Yes, sir.
And that means that maybe you don't have any witnesses, expert reports, or exhibits at this point because you don't know what to expect.
Right.
And this is related to the hearing on the 16th, right?
In the 14th, I'm not sure.
Okay. And there may be witnesses on the 14th too, as well?
Yes, Your Honor.
Okay. All right, so let's make it May 7th for disclosing witnesses, expert reports, and exhibits. We'll see what the state has to do with that, and we'll have a response maybe May 10. Is that sufficient?
Okay.
It's tight.
Are they having a
Well,
hearing?
that
for
gives
that?
us 3 days to respond.
3
I don't know
days.
if it's open or not.
Yeah.
No, I don't
That's
think
right.
it is. I think the next open one's the 14th.
Well, May 10 is I don't know when I'm going to read all this stuff too, because it's 14th. So if I don't have it by the 10th, then you're saying the 13th. I guess I can do that the night of the 13th. But also,
Oh, that's right. The
You know,
14th one's
the-
going to be
the
closed.
defense needs some space there too.
For God's sake.
And I don't think we want to push out that hearing. Can't do it by the 10th.
We have no idea what the defense plans
Right.
on doing, and that only gives us 3 days to read, comprehend, and respond.
We'll deal with it. We'll deal with the 13th then.
Yeah, I mean, we can try, and then if we
Okay.
need more time, we'll ask for more time.
It's just then on my end, you're looking at, I'm gonna have really more, I'm gonna need more time.
Your Honor, I don't expect reports. I expect to provide a witness list.
Okay,
I don't expect there to be reports.
exhibits.
There may be exhibits. I think there will be at least 2 or 3. I know some will be things that they've already given us in discovery, so they shouldn't be new and surprising.
Okay. I mean, it's hard to have these tight, timeframes because we also have other things to do, but Mr. Thompson?
Your Honor, it's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. Names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name. So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay, well, I mean, you don't have to have witnesses or exhibits, but you can have a response to say, well, this isn't fair, or whatever you want to say. Otherwise, I just need to push out this hearing. I'm stuck.
I appreciate that, Judge, and it.
Wait.
I guess we've said it before. It is more important to do it right than to do it quickly if we have to have a trade-off here. And that includes fairness to everybody involved, including the court.
If it suits him.
And I would prefer that this not be kicked off, but we're realizing that we're essentially 2 weeks or less away from these hearings, that apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say, and then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair process.
Well,
What are you worried about?
Explore this. I mean, how many witnesses are you expecting to have?
I'm expecting to have 2 on the 16th at this point in time. I'm not expecting either one of them to write a report. I expect a couple of exhibits. Some will be things from the protected materials that the court allowed us to have already. There will probably be 1 or 2 other exhibits, maybe 2 that the state hasn't seen before. I can provide those. I intend to provide those. On the hearing on the 14th, I think there may be 2 witnesses on that hearing, 1 for sure, possibly a second. We haven't made that determination yet. If there is going to be any PowerPoint presentation, I will provide that to the state as well. If we have an expert who hasn't written a report, then we won't offer expert opinions. We'll offer opinions about why we know the discovery is available, why we know these items are available. The state knows full well what they have and what they're withholding from us. And it's not going to be about what they're going to show. We don't know what they're going to show, but we know they exist.
Thank you.
The PowerPoint was hilarious.
I just want to have this hearing. I don't want to push it out. All I can say is do your best. I'll be fair about it. I'll give you more time to respond if you don't have that time. That's kind of where we are. And I just want to keep going. I mean, we got to get through all this discovery stuff so that we can get ready for the trial.
Well, and Judge,
Yes,
I do for the record need to clarify the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense.
Oh, really?
We have strived. We are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what they felt they had to file a motion to compel on, instead of being patient and wait because our discovery deadline isn't until September, that we'll have and be able to make that available between now and the hearings on the 14th, and there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we have been trying consistently through cooperative efforts as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. This isn't the motions for the subpoenas ducis tecum isn't the first TUI process, and the court is aware we've been pursuing TUI process for all types of information for months. So the characterization that we are just consciously withholding information to frustrate the defense is utter nonsense. That is not true. We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you, many of the things that the defendant has tried to itemize, when we talk to our people, they say, that doesn't exist. So, I don't know what we're supposed to do at that point, and we'll flesh it out at a hearing. And it may be that if they have experts who are going to say, well, such and such should exist, we might have to go find experts to say, well, in this case, it doesn't. Or no, we'll see.
Well, that's exactly why I want to close it on the 14th, because we're going to have many arguments, apparently, about issue by issue by issue. And some of that should not be out of it.
Thank you, Your Honor.
Your Honor, I want to respond to that, and I could give you particular examples of things. And it's already been ordered to be given to us, the CAST report, which was a draft that we were promised to have by March 31st. It's May 2nd. We don't have it. So for the prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things, Your Honor.
Oh,
That's there.
You know what?
It was him.
Let's not go there. I mean, we can sort that out on the 14th. I mean, I read everything. That's what the state was saying. I trust both of you, okay? Your integrity. So I don't want this pointing the fingers back and forth. I don't think it's very helpful. Doesn't really help me. It started at the last hearing, and I really want you all to just tone it down a little bit.
Tone it
I mean,
down.
you can argue all you want, but when it starts to be personal, it's destructive.
Kids.
I mean, you're really, really good lawyers. So
you're good kids,
just
really.
focus on issues.
Don't make me turn this trial
Your
around.
Honor, we're happy to. And when we get the CAST report,
No one
we'll
will get a
disclose it.
slushy.
We do not have it. We are not withholding.
I-
As simple as
I
that.
read that last night. Okay. I'm very prepared about what the issues are, okay, about the discovery. And that's why I want to be able to hear from both sides, okay, what is the problem with this? What do we need to go forward? And I'm going to try and help that. And I expect that both of you do the same.
Your Honor, I do have several other examples, but in light of what the court said, I won't provide them right at the moment. There are other issues.
I understand, and I understand your frustration. And it's a big deal. It's
It is a
really
big
important. I understand that too, and I acknowledge that. Sometimes,
Acknowledged.
we just can't quite get what we want from other people who might have it that don't want to give it up. So that's
I have that
No,
problem.
it's
one of my challenges on the 14th and probably at the 16th too. Okay. Moving on, we've got,
Let's just move on. Everyone move on.
all right, some of these pending motions, there was no request or no response from the state. And I'm thinking that the motion to unseal parts of the IGP materials and motion to allow defense investigators to review the IVD materials that we're going to be addressing that on the 16th. Is that,
16.
Yes, sir.
that's the state's understanding. Ms. Taylor?
Yes, Your Honor. Well, we're happy to have a hearing on the 16th for both of those
Please.
issues as well.
Great. I'm just trying to make sure that we're all on the same,
Are we allowed to? Is that one going to be open?
same page, or at least the same date. But I wondered, okay, there's been a response on the alibi issue, and I don't know if there is a request for a hearing, or if we just kind of let that lie for now. I don't know. What was your intention there, Mr. Thompson?
Yes, Mr. Thompson.
I think at some point we're going to need a hearing on it. We're busy enough for the next couple of weeks with these other hearings, so we haven't reached out specifically on that.
Okay.
If the court would like to select date while we're together today for a hearing, we would be happy to.
Why don't we just
stick
wait
with that
until
calendar.
the 14th or 16th?
That's fine.
And there may be issues that come out of discovery that have some bearing on that issue. I don't know. You don't have to say anything, Ms. Taylor. It can read your mind then. Sometime, maybe not. All right. Okay, I'm going to sign those subpoena deuces taken. The FBI. I believe that's related also to the 13th supplemental. Maybe I'm kind of losing track of it.
Your Honor,
Well,
it does relate to one of our discovery requests, and I'm sure one of the numbered motions to compel. I'll note that when I speak about that on the 14th.
Okay, great. All right. Are there any other issues that we need to address today? Mr. Thompson, Ms. Jennings?
Well,
Okay, Ms. Taylor?
hang on. So, Benjamin, yes and no. Yeah, there are lots of things they can't openly talk about, lots and lots. However, Ann Taylor wants certain things to be spoken about publicly. She said that. So she really, really, really wants the public to know that certain items are being withheld, right? So she wants the public to know that, especially like regarding the alibi, that's a big deal at the moment because that's topical. It's in the news, and people are mocking this alibi. They're saying that, oh, well, he was out stargazing, he was out driving. It's hilarious. That's not an alibi, right? So she wants people to know that the state, the FBI, they're withholding information which corroborates this alibi, right? It's exculpatory evidence, right? And there's other exculpatory evidence as well. So exculpatory evidence regarding the DNA. So this DNA, the way they've obtained it potentially could be unlawful, and that's important, right? So a lot of people are just all like, oh, well, it doesn't matter how they obtained it. If it's him, then it doesn't matter because his DNA is still there. Well, it does matter because it has the due process is going to be his due process is going to be tainted. So the trial is going to be tainted, and it's an appellate issue. So what's the point of going forth with this if he's just going to be able to come back on appeal anyway? And then people are going to say, oh, he just got off on a technicality. Well, this is a problem. There's no point in putting this forth to trial if the DNA evidence has been obtained unlawfully, right? So you might as well just take the DNA away if they've gone and taken this, if they've gone and received this DNA information unlawfully. Might as well just admit it because it's going to be found out. It's going to be found out.
Look at Jensen.
Yeah, look at Jensen. So that information
Letter from the grave.
It's nothing to do with DNA, but that evidence.
Yeah.
That evidence, the judge knew all along that evidence was going to be appealed, and it was appealed at the Supreme Court level, and that whole trial had to be
Done again.
And yes, so this is all what Ann Taylor is trying to do, is to head this off at the pass.
Yeah.
Wouldn't it be terrible to have to go back through all of this again?
I mean, they're probably going to have to in Delphi, assuming the guy lives to trial and can survive prison waiting for appeal.
Hello, under your scars.
Oh,
Sad he technically could walk, as obtained how it was like that. That's insane. Well, no, under your scars. That's not how it works. So sad he technically could walk as obtained how it was like that's insane. No, that's not how it works. Okay, so he's not going to walk on a technicality. If he is guilty, he will be found guilty. If he is not guilty, he will be found not guilty. Let's hope.
Yeah.
Right? So he is right now innocent. Okay. So if his DNA has been obtained unlawfully, it should not even be presented at trial. Right? Now, just because his DNA is on that knife sheath, that does not make him guilty. Right? It is touch DNA.
Transfer.
Now, it same thing. And it could be there for any reason. He could have picked that object up, or even picked something else up and shaken the hands of somebody who picked that thing up, right? It could have been at a garage sale.
Or touched a doorknob at a gas station or Arby's, and then somebody else went in, grabbed the doorknob, picked up his DNA.
Yep, it could have been planted there. There were no body cameras on, right? So there's a gazillion ways that DNA could have gotten there. Where's the rest of the DNA? Why is there none of his DNA at that crime scene anywhere else?
That's really sus.
That's very sus. And also, why is there none of the victim's DNA anywhere? In his car, in his apartment, anywhere. So the stunning lack of DNA is actually more concerning to me. However, all that said, he may very well be convicted on that very small piece of DNA. It's important how that was obtained, therefore how it gets into trial.
We just want to make sure the right person is convicted.
The right person must be convicted. And if there's somebody else out there who is guilty of this, they should be found. And unfortunately, if he is not guilty, we've wasted a very long time trying to, which could have been used to find the actual killer. They should have more evidence than just the DNA anyways. They absolutely should have more evidence. And that is why this thing about the white Elantra should have been properly identified. There is nothing that says that is actually his car. Then we have the problem with the cell phone. If this cell phone turns out to have been somewhere else at the time, the whole state's case falls apart. In my opinion, it falls apart because they have said all along that the phone just stopped responding to the cellular network at the time of the crimes, right? So what if it didn't? What if it didn't stop responding? What if it can actually be found to have been able to be tracked to GPS data and it was nowhere near the site of the crime at the time? Suddenly this transfer DNA, touch DNA, is nowhere near as convincing.
Yeah.
Now, this the use of transfer DNA is not even admissible in many countries, including this one, mine. BK is loving the attention. Are you kidding me? Are you kidding me? He is in jail awaiting what could be a death sentence. Do you think he's loving this? You're trolling. You're trolling.
Oh well.
Good to have you. Good to have a viewer though. It's nice. I've got a small channel, so extra viewers cool. Good to have you here. Anyway, let's finish this off.
Yes, Your Honor.
Okay, go ahead.
I want to say this in a way that doesn't come off finger pointing, because it's not. This is about how busy everybody is and how much time it takes to communicate to get hearings set, because there's a lot of people going a lot of directions. I would like the court to consider setting hearings twice a month, every other week, and the court can vacate those hearings if neither party notices something up for that hearing. There would be 14 days notice for either party if we have hearings on that basis. But that way we could notice up specific hearings and just have those set dates so that we're not bugging the prosecutor's office for a stipulation and bugging the clerk's office for a hearing and waiting to find that out. It would speed things up to have 2 times a month that we would know if I've got 14 days before this hearing, I can notice it up and it can be heard by the court. So that's our request, is that the court just reset a couple of hearings. These would not be like the lengthy motions to suppress that we'll probably need a couple of full days for. These would be these shorter motions that we could deal with in 1 to 2 hours.
All right. Thank you. I actually mentioned that at one of our hearings. That's what we need to do. I think it would be more helpful to, I guess, have better communication. Okay. I don't know. Maybe you are having good communication.
God, you sound like my ex.
With each side. It is hard, to get a hearing when the clerk has to contact you, or contact Mr. Thompson, and this goes back and forth. I mean, it takes a lot of time for your assistant, the clerks. At the same time, I have a lot of other cases, and I have a lot of jury trials going from here really to the end of the year. So it's hard for me to say, okay, we're going to have it I think I offered Thursday, like a Thursday afternoon. So I'm willing to do that. I might just set like once a month, maybe, and then if you need something more, just let us know. But I'll look at my calendar and set that up. I mean, I know you come down on Thursdays generally. So that's a good day for you, right?
Thursdays are fine, Tuesdays are fine, Fridays are fine. Wednesdays are rough, but whatever day works for the court, I'll make that work. I just think it's more important that we have a place to put these hearings so that everybody's not spending a lot of time asking each other what day's okay, what time's okay, that we just all know that this is the time. So whatever day works best with the court schedule, Your Honor, is just fine with me.
Thursday afternoon is probably.
That'll work.
Monday is impossible. So what do you think about that, Ms. Jennings?
Yeah, that makes sense. I think Thursday afternoon be fun for the state.
Do you think,
Thanks.
Twice a month? It's probably going to ramp up.
I suggested that just because then there's 14 days to the next hearing, so everybody would always have enough notice. This is why I suggested that, and to know that we have those to iron out issues that are going to arise. Again, these aren't for the motions to suppress; those will come later.
Okay. Maybe we'll start with twice a month to get through all this discovery. I hope we can all get past that soon. And move forward a little faster. Okay, anything else then?
No, thank you.
Okay, great. Well, thank you all, and have a good day. Beautiful day. Thank you.
Have a beautiful day. Beautiful. What do we think, guys? What do we think?
It was interesting.
Hey, J-Rock.
Hey.
How are you?
I'm assuming 69 is already taken.
Okay. Is Sean streaming right now?
I don't think so.
Don't think so. Because I'm gonna when I redirect you, I'm actually gonna redirect you over to the Murder Church bingo that's going to be happening at 9 p.m. Eastern, but that's not starting for a little bit.
I thought it was...
Anyway.
Oh yeah, you're right.
Okay.
Not
9 p.m. Eastern. Yeah. Anyway, so I thought we might just have a little bit of a chat about that. Cool. Hang on just a sec. Stop this. Cool. Pause that, and we go into this mode. Hello. Hey. Hello, Bryan. How you going?
Oh. Give him a little pat on his head. It's okay.
Speaking of pats, I just get the cat in just a minute.
Okay, yeah, get the cat. I'll talk.
Yeah.
Entertain yourselves, chat. Now, let's see.
Hello, what do you think about this travesty of justice?
Aww.
Hang on. What do you think? Meow? Meow. Purr. Meow. That Seraph has nothing to say. I just moved him from his spot, so he's not too happy. You okay? You all right? Yeah, he's fine. Okay.
Yes. So tomorrow.
What about tomorrow?
I've got Jensen at 5 p.m. Eastern.
Okay, no, I asked you about what you think about all that.
Oh, yeah.
I'm not here to ask you for grifting. I was asking about the thing.
Yeah, it's very interesting. Yeah, it's kind of state needs to get their act together, but that's typical.
They're not going to. If you haven't noticed, it's been, how long has this been going on for? A year and a bit?
Yeah.
And they've been playing these games ever since. And what drives me mental is that they're really happy for things to be in the public when it suits them. Yeah. And then as soon as it doesn't suit them, they start to look bad. They're all like, oh, let's close off the hearings. And then they start to act all dumb and go, oh, the defense is changing their tune. They want to make everything public now when they wanted to suppress things before. They wanted to seal things before, right? And it's like, no, they wanted to seal documents. They didn't want to make the hearings closed. They never did. They just wanted to seal documents. It's important to seal the documents because it's full of names and things. That's what you do. You seal documents because they're full of sensitive information. That's what you do. That's what sealing documents is for. So that's completely normal. Yet they never asked to close the hearings. So the defense has always wanted the hearings to be open. Yeah. This is not a brand new thing. This is not a brand new thing. So for the state to get up there and go, oh, now you want to keep the hearings open, that's just a lie. Like, lie. They're liars. Big liars, pants on fire. And it's the state that wants to start closing the hearings off. Why? Because they're starting to look really bad. It's really looking nasty. The way Ann Taylor is getting up and really voraciously defending her client and speaking about how the state is withholding important discovery about how her client is. There's exculpatory evidence about her client. What has the state got to hide? Where is the cast report? Where is the IgG evidence? Why is it taking so long? How come they give her just like one little piece when she's asked for all this other stuff? It's getting more and more obvious what's going on. What have they got to hide? So, and then they go, oh yeah, let's close the hearings. And then they go, oh, it's different. This is not a trial. These are hearings. And the judge goes, oh, yes, but if we start just giving people little bits of information without context, then what? This is not a trial. And it's like, dude, it's too late. It's just too late. You can't just turn around now. If this hadn't started with the state just throwing a PCA out there full of allegations and encouraging people to share it, they really did. Mm-hmm. It went absolutely viral, this PCA.
Yeah.
Oh, she's incredible, J-Rock. Have you been watching, J-Rock? Hey! You...
What the hell?
Oh, wait. He's been getting more and more feisty lately, hasn't he?
Oh.
My jumper is just wrecked.
Oh.
Yeah, he's been getting more and more feisty lately. BK is, yeah, look, he struck gold with her.
Yeah.
But then again, there was like two to choose from.
Well, yeah.
There's two public defenders that are death penalty qualified in that area in Idaho, I believe. So yeah, it was between two of them, and I'm sure they're both very good. Ow. He's got some teeth on him. Yeah. Stop it, Bob. Yeah. So where was I at? You can't just turn around now and say, oh, let's stop giving the public bits of information when they've received so much. We all know so much about this, right? It's kind of like with the Karen Reid case. The trial's just started, but the public knows so much. Like, there's been 5 or 6 motion hearings and probably tons of other little hearings in between with Karen Reid. I haven't been following all that, but I'm amazed at how much people know about trial, and the trial's just started, right? And it's the same with Kohberger. We know, I think, probably too much about this, yet we're still waiting for a trial, and we are hoping that there's a lot more information, because it just is. We feel like there's got to be more. There's got to be more. The state has to have more. There's so little there. It feels like there's just nothing there to really convict him on. Hopefully they've got more if they're really going after this person seriously. Or maybe they don't. Maybe they don't. Stop it, Ronnie. I honestly hope the exculpatory evidence is enough to exonerate him. But if this thing goes to trial, I look forward to seeing her fight. Oh, me too. It's going to be, this trial is going to be fire. It is going to be fire. She is incredible to watch. I mean, just watching her already.
Yeah, she kind of reminds me of Morrissey.
Yeah, she's a bit like Morrissey.
And Alec Baldwin and Hannah trial.
Seraph is 17. Yeah, he's super based. Yep, thank you. Seraph's happy to be 17. Yeah, because he is 17. That's his age. So cool. Seraph can be 17. Guys, people who don't know what we're talking about, we're part of Sean, potentially criminal, his cult. And I'm number 7. J-Rock is 2. Sean's 1, obviously. Pie Case is 3. And Clyde is 4.
I'm 6.
I chose 7. 7's one of my lucky numbers, so I chose 7. And yeah, so whenever J-Rock and I greet each other, I'm like, hey 2, and he's like, hey 7. So that's what that's all about. Can you be 0? I don't think so. That would make you higher or before the cult leader. So I don't think you can be 0. Yeah, Seraph is super duper based. You want to be 6? I don't know who's 6. J-Rock's got the list. Okay, anyway. Can you be, you can't be 7 because I'm 7. You could be 77 maybe. Yeah, you got to ask J-Rock. He's got the list. He knows who's who. Okay, so what did we find out is that the next open hearing is the 16th?
I believe so.
And that's about IgG. Right, so that's the genealogy stuff.
Right.
And with the genealogy stuff, I think what's still on the table is how that was obtained. So that's about like the 23andMe and the Ancestry.com chain. So how the information was obtained, whether or not it was lawful. So we're still waiting. Again, state's still waiting on discovery, so they can trace back whether or not that was lawful, and they will try and get that thrown out. Again, I don't know whether that will happen. That would be a huge win for the defense if they can get that thrown out. Just imagine if that DNA on the knife sheath was not able to be entered into evidence. Huge, 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 huge. I really doubt it. I think that's going to be that's not going to be worth pursuing for them, but they can try. We'll see. What's this? I emphatically expect the exculpatory evidence is enough to exonerate him, but should he go to trial, I look forward to a good fight. Yeah, look, I think there'll be potentially enough there, assuming that they get the exculpatory evidence from the state. It's not looking very good right now. They're trying everything they can to just sort of bluff their way through to the discovery deadline. Just sort of pretend like, what did you ask for again? Oh, what's the cast report? Oh, yeah, we thought we gave you that. Oh yeah, we gave you a piece of, yeah, that was that one page. Oh, you wanted that bit. Oh, okay. Well, we'll have to ask again. Yeah, righto. We'll get back to you. Didn't see your email. Sorry. Must have gone into junk. Have to go have a look. Oh yeah, you did ask for that. Sorry. Let me just check again. Yeah. So there's a bit of that going on. And September is the deadline. You post the list in Sean's locals under safe house. Yeah, you're 77 now, Becca. Very good. Yeah, so there's a bit of that. Let me just check something, guys. I have a list. Kohberger. Where is it? Okay, so I've got a note here. The truth is the defense is trying to find out just like the rest of us. They have data that seemingly places BK in a different location that night. But if you read carefully, the filing is demanding the state to compel evidence. The FBI cast report in particular, the defense wants to know if the state knew this same information and withheld it from discovery, or if their data contradicts what the defense has. It's not exactly confirmation just yet. Yeah. There's a little, hang on, let me just see. I hate the way I don't know if anyone else uses bookmarks in X. I put bookmarks in, and what it does is it actually like messes up the times on them. So you can't like look in order. Anyway, guys, we'll finish up now. Thank you all for being here. We are going to redirect over to Publicly Buzzed. They have a stream in half an hour time. It's super fun. So how it works is they have their Sunday stream is every week. They run a retro trial. They just finished doing Joel Guy Jr., who is like the dude who took his parents and choppy them and put the mum's head into a crock pot and boiled it. And then what they do is they've just finished that trial. So tonight they're about to choose what their next trial is going to be. So they have like 8 or 10 of them, and you go in and you vote on which one you want to watch next. And even if you're not going to stick around and watch the trial, just being involved in the Murder Church bingo is super fun. So go over and hang out with Steve and Dan, his brother. Steve was here on the last Kohberger stream. Remember Steve?
Yes.
He's super fun. Yeah, go over and hang out. And they do it in heats. All right. So what they do is they explain to you what the trial's about. They give you like a 30-second, 1 minute sort of trailer about what the trial's about. So you can see whether or not it interests you. And then you vote A or B. And whatever wins A or B, that goes through to the next round. And then you look at another set and then you vote A or B. And then those two then head off into the next round. And you won't believe how fun it is. Plus, you learn about some different trials from the past. And then eventually you get down to the final and you choose the trial. And everyone, it's popular vote. What trial you watch next? And then on a Sunday morning, I think it is, they stream the trial. Is that right?
Yeah.
Sunday mornings? Yeah. Because I'm always asleep when they are they're streaming it. Sometimes I catch the beginning of it because Sunday morning is my Monday 1 a.m. or something is when they're streaming it. But yeah, anyway, so I'm going to redirect over to that. That's in 25 minutes. Yeah, cool. So I'm going to redirect over to that. And I'm going to go chill for 20 minutes and then I'll go and hang out in their chat and vote on different trials. So yeah, that'll be fun. Make sure you say hi to Steve and Dan from me if you hang out over in the chat, or even if you just are sitting there waiting, just type in Excited Utterance Raid so they can see that we've raided them. Thank you guys so much for hanging out with us today, this morning, my Saturday morning. It's been super fun. Yeah, it is fun, J-Rock. It's a great idea. I wish I thought of it. I love it when people come up with cool ideas like that. And then I'm like, I wish I had that. And we will be definitely streaming every hearing, every update on Kohberger from here on in, and keeping across it. And follow me on Twitter also, just making sure that keeping up with all the updates and commenting on those whenever we can. Cool. Oh, one more thing. before we go, and that
Jensen
is
tomorrow at 5 p.m. Eastern, by the way.
Yeah, that. Is there a link?
Yeah. Just one sec.
Yep. Chuck
Posting
the link
now.
out there, my friend. Chuck the link out there, my friend. Indeed.
We will be watching his interrogation. Never before seen.
Oh, the interrogation. Never before seen interrogation.
Just some clips in the trial, but not the whole thing. So we'll be starting
Too
that.
exciting. Oh, yay. And Wilhelm has done work on the interrogation as well. I can't wait. I can't wait to watch that. Mark Jensen, Saturday, 5 p.m. Eastern. Cool. All right. So the interrogation of Mark Jensen, never before seen. Can't wait for that. And also, Hearsay for Days, Sunday, Karen Reed trial special edition. Guest to be announced. I have not decided who to bring along for that one. Lots of people have been streaming that one. So, yeah, I'll grab somebody. Don't know who yet. Maybe I might see if Brandy's interested.
Cool.
We'll see. Don't know. But anyway, there's so much chatter about Karen Reed. How can I not do a 100% Karen Reed stream this week? That will be Sunday, 4 p.m. Eastern. That's cool. Okay, that's it, guys. Finally going to end the stream, and I'll chuck you over to Publicly Buzzed. What a fun stream this has been. Thank you, everybody, for being here. Time to end it. Where are we? There we go. I'll do my Hearsay for Days one.